Okay, so Mr. Adebimpe, yes. So I'm going to hand over to Mr. Adebimpe now to start his class. Please, I kindly urge you guys not to interrupt the lecturer while he's taking his class. He's going to give you the opportunity at interval to ask questions. All right. So let me also confirm you guys can hear me. Ibrahim Oladipopo Shitu, can you hear me? You can just type.
Yes, I can hear you.
Okay, nice one.
I can hear you, sir.
Okay, Kehinde Obie Sesson, can you hear me? It seems you have some problems with your mic, but you can just type 111 in the chat while you try to resolve that problem. So I will hand over to Mr. Afeez Adebimpe now to start his class. All right, thank you.
Hi everyone, good morning. My name is Afeez Adebimpe. I'll be running you all through business law session. Business law is one of the major courses you are going to learn in the foundation level of ICAN program. We at ICAN Online Tutorial Center have decided to come up with exam-focused slides that will help you in passing your exam. At the end of this lecture, what is our major objective? At the end of this study session, students should be able to divine the Nigerian sources of law. You should be able to divine or explain different sources of law that we have, and also evaluate the existence of customary law. Let me take you down some history. During your secondary school level, some of you are in commercial class, and I'm quite sure you were taught government as a subject then. If you remember back then, I think in SS3, you will be taught constitutional development in Nigeria, when you'll be taught different kind of constitution stage from one level to the other. And also at some point, they will have explained to us colonialization, how the British colonized Nigeria and how we are set free in 1960. All these are embedded under this subtopic, sources of Nigerian law. To start with, in life, you need a foundation to build so as for you to move to the next stage. And that is what sources of Nigerian law is all about. Nigeria as a country has our own established legal system that we operate in governing the authorities and at the same time the subject. What do we mean by sources of Nigerian law? Let's just define a simple rule. When we say sources of law in its context simply means the fountain of authority where law derives its validity. By so doing, a law is a system of rules and regulations that are enforced to govern a particular people or a particular society. That is what we call law. Law refers to as rules and regulations, guidelines, customs, conventions that governs a particular group of people, society, or a country. Now, put to say, Nigeria as a case study, how do we define our own law? Or how do we derive our own law? What are the bases with which we develop the law that we use today? And that is what sources of law is all about. Sources of law refers to the root or the fountain of authority where the Nigerian law, put to say, derive its validity. So, Nigeria as a country has the following sources of law. That is, our law is derived from 5 major places or from 5 major angles under the law. The first one is what? Received English law, followed by Nigerian legislation, customary law, case law or judicial precedent, and international law. For the purpose of this ICAN class, the Nigerian sources of law can be derived or can be categorized from 2 ways. The first way, we can say direct law, and we can also say indirect law. But to follow the common classification of Nigerian law, we have identified 5 major. The first one is Nigeria English law, that is received English law. What do we mean by received English law? Prior to 1900, Nigeria has its own pre-colonial system, where we have our own system of government before the British people took over. At exactly January 1, 1900, history added that the British took over the territorial angle of Nigeria, its economy, and also its political system, thereby introducing 3 major laws into our system. Under received English law, we have 3 major laws under it. The first one is called common law. The second one is called doctrine of equity. And the third one is called statute of general application. In a simple term, what do we mean by common law? This is the law that is fundamental to the people of England. Citizens of England are regulated by common law. One major criticism to common law is that it is very rigid and does not take into consideration the aspiration of the people. It's so rigid that some legal issues, the way it is decided, people did not find it interesting. As a result, we have what we call doctrine of equity. Doctrine of equity, I must say, is developed after common law, after the people agitation. So doctrine of equity came to existence. One interesting thing about doctrine of equity is that it does not come to cancel common law. Rather, it's used as a support to whatever we have under common law process. For doctrine of equity, we have some simple ingredient that comes with it, and that is what we call maxims of equity. These maxims of equity, we as students, we need to understand them one after the other, because examiner can ask you, define doctrine of equity and identify 5 major maxims of equity. The following are the maxims of equity. The maxims of equity actually explain those ingredients of equity, those principles that comes with equity. The first one is equity follows the law. That is the first one. Equity follows the law. Going by my slide, the first one here is equity will not suffer a wrong without a remedy. Equity will not suffer a wrong without a remedy. Meaning that equity guarantees justice. That's what that means. Number 2, he who comes to equity must come with clean hand. This actually explains the next maxim that follows it. That is, he who seeks equity must do equity. So for you to seek for justice under the law of equity, you must also seem to have been doing equity. You must also seem to be of justice in your own nature and dealing with people. Where there are 2 equities, or where the equities are equal, the first in time prevails. It's also a maxim on its own. The first one that I mentioned, equity follows the law. What this simply means is that equity is expected to guarantee the interest of the people. Thereby, it follows the fundamental law of the land. Any law in existence that is used at that particular point in time, equity take it into consideration and find a way to ensure justice over rigidity. Delay defeats equity, or equity aids the vigilant and not the indolent. So in equity, you must be fast as much as possible. You must ensure that if you have a particular case, all your evidence are in place to support your position. Equality is equity. This is self-explanatory. Equity looks at the intent, substance, and not the form. Equity looks on that as done, which ought to have been done. So what we are saying in essence, for this and this, they go side by side. Equity imputes on intention to fulfill your obligation. So what that means is that in equity, I don't really know what you have in mind, but I believe that whatever you do as action is a function of what you have in your mind. Remember, I said received English law, we have three major law under it. The first one is common law. Common law are those laws that are fundamental to the people of England. Because when the British took over Nigeria, it still added that Nigeria is divided into two separate entities. We have the colony and we have the protectorate. The people of colony are directly regulated and governed by the Queen of England. That is, they are under the British crown. While the people of protectorate are under the British government, however, they are subject in nature to them. So by doing this, so properly govern Nigeria, but they introduce them one after the other and one supplement one. For status of general application, which is the last part of this, Nigeria, the English received law, this status of general application has to do with special matters. They are laws that are derived from various adaptations of law. A very good example of this is Partnership Act of 1890. That's a very good status of general application. Basically, they are laws that are used on certain matter, business matter, marital matter, infant relief matter, and so on and so forth. That explains the number one sources of law, which is the Nigeria received law from England. That is, received English law. So number two sources of law is the Nigerian legislation. This happens to be the locally law, the Nigerian made law, the law that we made in our country, not an imported type of law. So under this category, we have five major, but I've decided to add one more, which is the Nigerian Constitution, because today, all the law we use in Nigeria has its own tenet or basis from the Nigerian Constitution of 1999. Under the Nigerian legislation, which is the locally made law, we have 6 types of law or 6 types of enactment that we want to look at. The first one is the Act. Here we call it Act of Parliament. The Act represents law or laws that is being made at the federal level in a civilian regime. Act refers to the law that is being made at the federal level in a civilian regime. That explains what we have in our slide. There are laws passed by the National Assembly, which is composed of the Senate and the House of Representatives in a democratic government. So the Act of Parliament represents the law that is made by the National Assembly in a democratic or civilian government. Number 2, decree. Decree represents law that is made at the federal level under a military government. Law made at the federal level under a military government. That is what we call decree. Laws. Laws are various enactments that is made by the State House of Assembly under the democratic government, that is under a civilian regime. Now, the difference between Act of Parliament and laws is that Act of Parliament is made at the federal level, while laws is made at the state level, but both in the what? Civilian or democratic government. Edicts. Edicts are laws that are made at the state level under the military regime. So now it goes like this. Act of Parliament, laws move together. They are both made in the civilian or democratic government system. Act of Parliament is issued at the federal government level, while laws are issued at what? State government level in a civilian regime. For decree, Decree is issued at the federal level under the military regime, while edict is issued at the state level under the military regime. Number 5 is bylaws. Bylaws are various laws that is made at the local government level. Bylaws are various laws that are made at the what? Local government level. Another name for bylaw could be seen as delegated legislation. So delegated legislation has to be those laws that is being made by other arm of government other than the legislature. And lastly is the Nigerian Constitution. The Nigerian Constitution represents the book that contains the law of the land. The law of the land is contained in our Constitution 1999. In the Nigerian Constitution, we have various sections that explain different provisions that is expected of a country and its government. So the Nigerian Constitution represents the book that contains the rules and regulations with which the government of Nigeria as a country must operate. Remember, we said we have 5 major sources of Nigerian law. We have looked at the received English law. We have looked at the Nigerian legislation. Now we are looking at customary law. From the word custom has to do with the people, tradition, and so on and so forth like that. So customary law represents the law that is generally acceptable by the people. Law that is generally acceptable by the people. So in Nigeria, we have over 250 ethnic groups. Each of these groups has their own custom and tradition that is peculiar to them. That suffices me to say each and every one of them have their own laws that regulate them. That is what customary law is all about. It is the law that is organic and fundamental to the indigenous community of Nigeria. Going by what I have in my slide, customary law can be described as a body of rules regarded as obligatory by members of a particular community. Customary law varies from one community to another. That explains what I mentioned earlier, that in Nigeria, we have over 250 ethnic groups, the major one being the Yoruba, Hausa, and Igbo, popularly called Wazobia. Each and every tradition we have in each and every community that we have in this country have their own peculiar law that is attached to them, and that is what customary law is all about. In Nigeria, and based on the law, we have 2 major types of customary law. The first one is what we call ethnic customary law. So the ethnic customary law is particular to each ethnic group in Nigeria. The Yoruba people have their own. The Igbo people have their own. The Hausa people have their own, and so on and so forth. The other types of customary law that we have is what we call non-ethnic customary law, which is also called Islamic customary law. Islamic customary law is that one that belongs to people of that faith. Is that one that belongs to people of that faith. For instance, it is expected to be a law acceptable by the Muslims within certain jurisdictions in Nigeria. We have 3 major characteristics or features of customary law. The first one is that customary law is unwritten. Anything we call customary law is like a custom, convention, tradition. Most of them are not written, but Islamic law is written. For the Muslims that believe in Islamic law, their law is derived from 2 major sources, the Quran and the Hadith. The Quran is believed to be the sacred book revealed by the God to their prophets, while the Hadith is believed to be the teaching and practice and tradition of the prophet. So they believe in all of this and they ensure it governs their daily activities and their ways of life. For Islamic law, it is written. For ethnic law, it is unwritten. Now, customary law has an attribute of flexibility. Because customary law is unwritten, that makes it flexible. That is, it can easily be changed. If we practice this today and our ancestors are saying, no, we practice another thing tomorrow, that is what makes it flexible. But Islamic law is not that flexible because it is written. So anything that is documented is hard for anybody to just change without following a due process or without proper consultation. Lastly, is generally acceptable. Customary law is generally acceptable. Both Islamic law and ethnic customary law, they are all acceptable. Now, for example purpose, I can
Hello, everybody. Sorry about the interruption. I guess the lecturer is having some technical issues. So let's give him a few minutes for him to join the class back. And don't worry, any parts you missed, you can ask him question. That's one. Number two, also that this class is being recorded, so you can listen to it after this class. The link will be provided for you guys to go watch the videos. All right. Thank you so much. So let's just hold on. Let's give him a few minutes for him to join the class back.
that is indigenous and applicable to a particular member of certain ethnics in Nigeria, while Islamic customary law is that law that is applicable to people that believe in the Islamic faith. And I said these are the Muslims. They have two major sources of law under the Islamic law, the Quran and the Hadith. Now, what are the characteristics of customary law? Customary law is largely unwritten except for Islamic law. Islamic law, since as its basis or its sources of law from Quran and Hadith, it means it is written, thereby making it an exception to generally unwritten principle of customary law. The second one, it is largely flexible also. Customary law is flexible. Whatever that is unwritten will surely be flexible. But Islamic law is little rigid because it is written, and to change some provisions, you have to follow certain process. Lastly, it is acceptable. Both Islamic law and the ethnic law of a particular group of people is acceptable because they see it as their custom and tradition. Now, before customary law can become part of Nigerian law, or before it can be recognized by the court, it must pass through two major tests. The first one is the validity test, and the second one is the proof of existence test. For validity test, we have three components under validity test: the repugnancy test, the test of incompatibility, and public policy text. At this point, let me unmute you all. I want to entertain questions. At this point. Before we move into the various texts under customary law. Please, do we have any questions so far?
Good morning.
Good morning, sir. Mr. Shitu,
Yes, sir.
good morning.
Yes, sir. Thanks so much for the lecture. Really appreciate it.
You're
My
welcome.
question is just when you started with the sources of Nigerian law.
Okay.
So you gave us list of the sources, which are 5, and but you emphasized that as far as probably the course is concerned, probably you will also like to describe it as direct law and indirect law.
No, I said.
Okay. That's what I'm not really clear of. Is it when we're asked of sources of Nigerian law, are we mentioning this fact, or we describe it as direct law and indirect law? And when we say direct and indirect, you've not really explained that.
Okay, sorry. Okay, sorry about that. Can you hear me?
Sir. Yes, sir, I can hear you, sir.
Can you hear me?
Hello.
Can you hear me?
I can hear you, sir. I can hear you.
Okay, beautiful.
I can hear you.
So what I'm saying is this. You see, the 5 classifications that we have. For example, for sometimes we can subdivide them into 2 categories. That is primary law and secondary law, or primary sources of law and secondary sources of law. In some texts, you see direct sources of law and indirect sources of law. Now, the first 3 that I mentioned, or the first 4 that I mentioned, represent the primary law, which is English received law, Nigerian legislation, and customary law. Customary law. Now, in some classification, judicial precedent is also added as part of it. So the reason why I didn't say much about it is that ICAN is particular about what they have in their module, and we are trying to follow their module so that by the time you get to the exam hall, you can easily see what we've explained to you in the class and give the direct answer to it. So you can pass in one sitting. Thank you, sir. Any other question?
Yeah.
Any other question? It means I can continue then.
Yes, sir.
So, repugnancy text. Under the repugnancy text, in summary, it is said to be repugnant if it is against natural justice, equity, and good conscience. So here, what we are trying to establish is a customary law will not be passed as a customary law, or a certain case or a certain law will not be passed in Nigeria as a customary law if it is absurd in nature, if it is rigid in nature, if it does not follow the natural justice of equity in nature. It is said to be what? Repugnant, thereby fail the text of repugnancy. That is what we refer to as repugnancy text. So the real meaning of repugnancy text was not defined under the law. However, we have various cases with which we use in explaining repugnancy text. A very good example of case is that of Edet and Essen. Now we move to incompatibility text. In summary, incompatibility text explain that, okay, for a customary law to be part of Nigerian sources of law, for us to pass it, it must be compatible to any law in place. It must be compatible to any law in place. So any law in operation must be in compliance with it. For instance, there's a particular case, we are going to look at it at the end of this lecture, whereby it was said that in 2015, there was a new regulation that killing of twins should be abolished. In 2015, there was a new regulation that killing of twins should be abolished. Now, in 2016, someone gave birth to twins, and the community leader came together to kill the twins. So the position of the law is very simple. Since we have passed a law in 2015 that killing of twins should be abolished, going forward, whatever law, whatever activities we want to do must be compatible with the existing law that killing of twins should be what? Prohibited. Thereby, the elders of the community planning to kill somebody in 2016, that act is not incompatible with the existing law that was initiated in 2015. Now, the last one is test of public policy. So, for test of public policy, we are saying that no customary law should be enforced if it is against public policy. No customary law should be enforced if it is against what? Public policy. So, let me cite a very good example. The court has refused to enforce certain rules of customary law because why? In the opinion of the court, it could encourage promiscuity, which is contrary to what? Public policy. So whatever that is against public policy should not be allowed, should not be passed as a customary law. So that is what we call validity test. It must pass these two tests, the text of incompatibility, and lastly, public policy test. Now, for proof of existence test of customary law, what are we saying? We are saying that for us to pass customary law as part of the Nigerian source of law, it must pass three major evidences or three major texts that we call existence of customary law. The first one is direct oral evidence. So we must see some people that witness the existence of customary law, the obas, the emirs, the chief, the elders, must be able to give us an evidence that truly customary law exists. It could be in form of narration or giving us the full details of stories of how those laws exist. That's what we call direct oral evidence. So where the people like chief, obas, emirs explain to us the existence of customary law at a particular point in time. Documentary evidence. For documentary evidence, this explains that, okay, for us to say customary law pass existence test under documentary evidence, we must have a write-up by scholars. We must see manuscripts by judges, by experts that is explaining the existence of what? Customary law. So what we are saying here is that it must involve the tendering of evidence, it must involve the tendering of books and manuscripts, findings about who that we consider as experts, who has substantiated the existence of customary law. Lastly is what? Judicial notice. So in trying to prove a custom by judicial notice, a person is simply asking the court to accept the custom as existing because a higher or coordinate court had in its previous proceedings repeatedly accepted the custom as existing. So these are a little bit linked words to judicial precedent. So judicial notice of customary law as a proof of existence is saying that, okay, this particular custom has been approved, has been accepted by a court of higher jurisdiction. Thereby, if we have a particular case that is similar to what has been accepted as existent by higher court of jurisdiction, the existing court should also accept it in their own proceedings. So that's what that means. We have what we call case law or judicial precedence. What do we call case law? Case law is also the same thing as judicial precedent, but what we see in ICAN is that ICAN loves to use the word judicial precedence, but you can say divine judicial precedence. It is only on few occasions that you are going to see them telling you to divine case law. So for judicial precedence, what do we mean? Judicial precedence has to do with sources of law where past decision of courts creates law for future judges to follow. So the decision made by one judge is binding on another judge to follow. That is what we call judicial precedent. So let me just give a very good example. At the zenith of the court is what we have the apex court, which is Supreme Court. So a particular case was decided at the Supreme Court level, and we have the conclusion. A similar case is being decided at the Court of Appeal level, at a lower court level, put to say. So what case law or judicial precedence is saying is that we need to consider in our decision the decision that was made or that was concluded in the higher court. That is what judicial precedent is all about. Judicial precedent refers to the source of law where past decision of a judge creates law for future judges to follow. So this source of law is also known as what? Case law. Now, under judicial precedent, we have two terms to consider: ratio decidendai and obiter dictum. For ratio decidendai, when you are making a decision and that decision forms part of law, constitutes a precedent, that is what we call obiter dictum. That is the material fact of a case and also the reason for that decision. That constitutes a precedent. That is what we call ratio decidendai. Now, for obiter dictum, obiter dictum did not constitute anything in the law. It's just a statement by the way, like those words that you used in order to communicate, but does not form part of your decision, does not form part of your pronouncement. That's what we call obiter dictum. So under judicial precedent, we have two factors to consider: ratio decidendai, which form the major precedent, the major decision in that case, and our conclusion therein, and obiter dictum, which is a statement by the way, which does not form part of the what? Precedent. We have three major types of judicial precedents: original precedent, binding precedent, and persuasive precedent. For original precedent, this has to do with the first time decision that is made by the judge. The first time decision that is made by the judge is what we call original precedent. The first time decision that is made by the judge. Binding precedent has to do with the decision that is made by the higher court of authority that is expected to be followed by the lower court of authority or jurisdiction. Lastly is what? Persuasive precedent. So for persuasive precedent, for instance, a decision that is made by court of coordinate jurisdiction is said to be persuasive. For instance, Lagos High Court, that is the State High Court, and Federal High Court, they are in the same jurisdiction in terms of power. Thereby, whatever decision that is made at that time is persuasive in nature. So it's not binding on either of the courts. Lastly is what? International law. International law is very important here, where Nigeria is part of members of some international organizations like United Nations Organization, Commonwealth, IMF, and so on and so forth. So law that is being used in that organization is expected to be binding on its members' nation. If Nigeria is part of them, it will be binding on us. I have some questions for us. This question is actually adapted from one past question. The Nigerian law has been tremendously influenced by English law, which constitutes the origin of a substantial part of our law. Secondly, Nigeria is a complex society, and this extends to our legal system. Required. Discuss the sources of Nigerian law. Let me unmute all so that we can bring in our opinion here. So I'll unmute you all. So can we look at the question together and give our own opinion as to the answers?
Good afternoon, sir.
Good afternoon. Yeah, Mr. Okay, I'm with you.
To my own view, require. I think they just want to probably by to give the solution, we may just probably buttress what was mentioned in the question by saying English has actually influenced, or the colonial masters have actually influenced our laws. But despite that, we have 5 major sources of Nigerian law, which are this, and that. We'll mention them. And
mention them. We don't know them. Please okay. Mention them.
The received English law, the Nigerian legislation, the customary law. Then we have the judicial precedence and international law. So okay. We'll explain each of them one after the other.
Okay, beautiful. I can't agree less, because that is the right answer to that question. So because they use the word discuss, you have to try as much as possible to explain in details, particularly those ones that are subdivisions. We also explain them and cite examples. So in our next class, I'll be looking at case studies, because business law has to deal with cases, because that's the major area that we need to explain to students the trick that ICAN will use and the best way for you to answer.
I don't know. Can we still ask questions, sir?
Of course, please go ahead.
Okay, I'm still not clear on the ratio decidendi, obiter dictum, and the binding precedent.
Okay, I will. Okay, let me quickly take that.
Okay.
Ratio decidendi. So, well, you understand what we mean by judicial precedence?
Yes, very well.
So now, the decision made that constitute that part of judicial precedent is what we call ratio decidendi. Okay. That is the material fact of that case. And that is what constitutes our decision. Obiter dictum represents the statement by the way. Those illustrations that you made that did not constitute part of the law is what we call obiter dictum.
Okay.
Let me cite a case for you. History added that Awolowo and about 10 people were brought before the judge and were charged for treasonable felony. So the case against them was felony. So felony is a very big case in law, and it means that certain group of people are planning to overturn an existing government. So that was the case that they charged against them. So the person to preside over that matter was Justice Sowemimo, which is actually from the state where Awolowo came from. Are you there now?
Yes, sir.
So before his conclusion, he said, my hands are tied. Just like you are my brother, I happen to be a judge in a particular case. And the punishment for that case is to sentence you to prison. You know, it will be a tight decision for me. Am I right?
Yes.
But I have to be sincere with myself. You have committed this, and all charges against you, they prove it right that you committed this case. Are you getting me? But yes, the truth is, you are my brother. In my own capacity, I wouldn't want to sentence you to jail. Yes or no?
Yes.
Because of that tie, because of that blood, Abi. But yes, let me yes. Now I think my facial expression will help in this case. You are my brother, yeah? I need to sentence you to jail. I have the preceding lawyer or the preceding judge to say. I now said my hands are tied. But I went ahead to sentence you to jail. Two things are involved. I said some things before I finally made my decision. Those things I said before I made my decision, but do not constitute part of the law, is what we call obiter dictum. So in that case, Justice Sowemimo said, my hands are tied. That statement constitutes obiter dictum. He went ahead to sentence Awolowo to 10 years imprisonment. That is the major substance there. The conclusion is that if you have charged, or if you are charged for felony, the punishment is sentence to what? Prison. So that is the what? We should then die. The material part of the case. Obiter dictum, the statement by the way. So in some terms, it's actually translated to be statement by the way. Sorry, we should then say that it's actually translated to be reason for the decision.
Material fact.
Okay. Yes, some also call it reason for the decision. But the summary is just that the material part of the case, the final decision in that word. What constitutes the precedent is what we call what? Ratio decidendi. What's the third one, sir? Binding precedent. So binding precedent is this. Now, a particular case is entertained by the apex court in Nigeria, which is Supreme Court. A decision is reached. If appeal court is entertaining a similar case that has been concluded or earlier finalized by Supreme Court, the decision made by the Supreme Court is binding on appeal court to follow. That is in theory. Just get it that way. In theory. Although in practice, it's expected to be like that, but there are instances that we can bring in so many objections and the reality of the case in question to display. Are you getting me now?
Yes, sir.
Any other question, please? Thank you. Any other question? Okay, since there's no question, so this number 2 is a multiple choice question. So for foundation level, you have two parts of the question. We have a case study question, essay question, and you have multiple choice question. So in our classes, we shall try as much as possible to bring the question in this way, both case study question and multiple choice question, so that you guys can familiarize yourself with it. So let's just look at what we have. Don't mind me. Sometimes ICAN can be so big for us to pass. Let me just pick that out. So you will study A, they will bring B. But the truth is, if you can study very well and get the material fact in what you have studied, you will be able to answer the question. In my slide, nothing looks like what we have here expressly. But if you truly understand my explanation so far, you'll be able to answer this question. So what is it? Law contained in judgment of court is A, case law, B, statutes, C, civil law, D, criminal law, E, common law.
It's definitely case law.
Okay.
That's judicial precedence.
And we lay. What if I say that is not the answer?
Huh? Because it says law contained in judgment of courts. That means that is the law that has been, probably the judgment that has been made in court so far and are being, how will I put it, are being as in the past judgments that have been made in court. That's what I mean by law contained in judgment of court.
Okay, beautiful.
And that
let's hear from Mr. Okay. Mr. Okay, what's your view? What's your view? Because me, I'm thinking the answer here is statutes. Mr. Okay. No, you have given me your view. Let's hear from Mr. Okay. I've mentioned my view. Statutes. That's what I feel the answer is. I'm not saying that's the final answer, but in my own view.
Sir.
So, Mr. Okay, is it there? Okay, I is muted. Okay, sincerely, you are correct. The answer is case law. The answer is case law. So that's how examiner will ask the question. Sometimes the question will not come directly. Look at all the grammar they gave us here. At the end of the day, it said discuss the sources of Nigerian law. So that's why you see a lot of people feeling ICAN, and you ask yourself, is it that they are not brilliant? The truth is they are very good. I can just of what this entails with that slide. That is a lecture on agency law. So let me quickly share my screen with you. That will not take us up to 1 hour, but I trust you are going to enjoy that session. 1 minute. Okay, let me entertain. Okay, fine. This is another section where we'll be looking at agency law. Let me share my screen so we all can be on the same page. You see this particular topic, examiner love to ask questions on it. And that's why I want us to pay attention to it. Examiner love to ask questions on it. That's why I want us to pay attention to it. So at the end of this lecture, what are we expected to know? So we should be able to define the term agency. We should be able to explain creation of agency. We should be able to explain the circumstances under which an agent can delegate his authority. If you are jotting, I want you to asterisk that last part. In my slide, I decided not to discuss a major topic on it. But at the end of the day, you'll be able to understand what authority can an agent delegate and what authority can he not delegate. From my explanation, you will get that. So we'll start with by looking at the term agency. So agency is derived or coined its basis from a Latin word, qui facit per alium facit per se, which means he who does an act to another is deemed in law to do it himself. That is, he who acts by another acts by himself. So if ICAN online tutors ask me, Afeez Adebimpe, to come teach you in our name, in law, it is seen as ICAN online tutors teaching you and not me. I'm just a representative of ICAN online tutor. Thereby, I am an agent to ICAN online tutor. So that's what the word qui facit per alium facit per se is explaining. He who acts by another acts by himself. So invariably, the lecture here is being given out by who? ICAN online tutors. Why I'm just a representative of ICAN online tutors. So what is agency? How do we define agency? So we have too much grammar here, too much grammar. Let me just give you the simple meaning of agency. Agency represents a contractual relationship or a fiduciary relationship between one party called an agent and the other party called the principal, whereby the agent brings the principal into a contractual and commercial relationship with the third party. So to some reasonable extent, agency can be seen as a tripartite contract, a contract between the principal, the agent, and the third party. So now, an agent is a mere intermediary between the principal and the third party. So once the principal and the third party have been able to see, an agent will go out of the line. So that's why, in some reasonable extent, you'll be told that an agent has no power in contracts of agency. He is just an intermediary between the principal and the third party. So who is the principal? The principal is the person that have authority. The principal is the person that appoints another party known as agent who helps him to come up with a good transaction with the third party. So a very good example is a landlord and a tenant. In the recent time, a tenant cannot get out directly from the landlord. You need to get it through an agent. That's what agency is all about. So the principal gives the agent the right to connect the landlord to him so as to give out the house to the tenant. So remember that the principal pays an agent commission for working for him. So the agent is just acting on the capacity of the principal. So the agent is the person who acts on behalf of the principal and is bound in principal in law. So the agent, like I mentioned earlier, brings the principal into a contractual relationship with the third party. So the agent is entitled to a commission. So authority. So what do we call authority here? So authority is that power to enter into a contract, power to carry out an authorized transaction. So the only person that owns that power is the principal, while it flows the power and authority to the agent. Now, who has capacity to enter into an agency contract? The principal has full-fledged capacity to enter into a contract. Now, the question is, can an agent enter a contract? Sorry, can an infant enter a contract? Yes. Insofar that the principal have capacity to contract, an infant can enter into a contract if he has an understanding of that contract. Please, I need you to understand that part. Now, capacity to act as an agent. Any person can validly be agent, even though they cannot validly act on their own. A very good example there is an infant. An infant cannot validly act on his own. Someone that is not sound-minded cannot validly act on their own. All people of sound mind are competent to act and to contract as agents. This includes minor with other or no capacity to contract on their own behalf. So we simply, what we are trying to say in essence there is that whosoever the principal delegate. So creation of the various ways with which agents, with which we can come up with an agency as my agent, you are my agent by express appointment. Implied agency. So implied agency is created by inference. A very good example is in a partnership business, a partner to a partnership business is an automatic agent to the partnership. So impliedly, we all know that if you are working in an organization, you are a representative of that organization. That is the summary of what implied agency is all about. So implied agency could come up in terms of necessity or by agency by estoppel. We are going to look at that. Now, agency by necessity is that type of agency that came to existence as a result of emergency situation. An agency by necessity came to exist as a result of what? Emergency situation. To prevent irreplaceable loss of another property, that item cannot be get back again. Then you have to come up with an agency relationship. That is what we call agency by necessity or agency of necessity. So in some way, agency of necessity is created under an emergency situation that require commercial substance. So an agent have acted so as to prevent the loss of another person's property or goods. Now, for exam purpose, 3 major conditions must be present before we can say agency of necessity is valid. 3 major conditions must be present before we can say agency of necessity is valid. The first one is that it is not possible for you to communicate directly with the agent of that goods. Sorry, it is not possible for you to communicate with the right owner of that goods, that's the principal, or to seek his or her instruction. Number 2, that there is an emergency situation, an imminent commercial necessity to do so. So lastly, that the agents must act in good faith. To act in good faith is somehow questionable. But for example purpose, you just need to understand these three principles. For you to say agents by necessity is in existence, three major principles must be present. That it is impossible or impractical to communicate with the owner of goods, that there is an emergency situation, and lastly, that the agents have acted in good faith. We are going to evaluate a question on that. Remember, the three conditions must be present. Agency by estoppel. Another name for agency by estoppel is agency by conduct. So in law, if you have not taken a precaution to stop someone to act that is acting on your behalf, if that person entered into a contract, it will be binding on you. So the law will prevent you from denying the existence of that. Mr. Rilwan, can you please mute your mic? We can hear you. Thank you. In a simple term, agency by ratification simply means that an agent carries out an act and the principal ratifies it. That is what we call agency by what? Ratification. About 6 conditions must be present. We can always read that on our own. But what is important is that the principal approve the action at the end of the day. Now, what are the effects of contract made by an agent? In summary, the effect of contract made by an agent is for the contract to be binding on the principal. However, effect of contract made by agent will be considered under 3 major headings. The first heading is named principal. Where an agent is contracting with a third party with the identity that this is my principal, any liability incurs in that contract, the principal will be liable. That's what we call named principal. For unnamed principal, where an agent acts for an unnamed principal, that is active but did not declare his principal to the agent, to the third party, but he has acted within the scope of his authority as an agent, then the principal will acquire the right and responsibility under the contract, meaning that the principal will be liable. Lastly, where an agent is acting as undisclosed principal, is acting for an undisclosed principal. So what do we mean by undisclosed principal? In this situation, the agent conceals both the identity of the principal and the fact of agency. That is, he did not act as if he's an agent. Neither does he make known to the third party that there is a principal that is acting on his behalf. The law says the third party can enforce contract against the agent. That is, the agent will be liable. However, if it is thereafter discovered that there is a principal, then the third party is at liberty to actually sue the principal and leave the agent. Termination of agency contract. Termination of agency contract simply refers to as the process of bringing an agency contract to an end. But before looking at that, let me unmute all so that we can ask questions where necessary. Let's ask our question. Welcome.
Okay, sir. Thank you, sir. Please, my question is actually clarification.
Okay, sir.
On the issue of entering contracts with an infant. I did not really get your explanation. You are trying to say infants can enter into a contract, probably if the principal is able. But I expect that if infant is entering into a contract, then the infant should be the principal.
And we're late.
I don't really get the explanation very well.
Okay, no problem. So I think in our next class, I'll be taking us contract law as a topic. But for now, we are just looking at them one after the other. So for agency contracts, we all know that an infant is anyone below the age of 18 years. And in common law, anyone below the age of 21 years is an infant. Are you there? Now, under agency law, if your principal is of age capacity, if your principal is of age capacity, that is not a minor. If your principal is of age capacity, then an agent can be an infant. What is important under capacity to contract other agency is that so far the principal is of age capacity, so far the principal is capable to contract, an agent can be an infant. So now the condition is an agent can be an infant provided he has the understanding of the business. Remember that under agency, the principal is an agent is just a mere intermediary between the principal and the third party. An agent is not binding by the contract. It's only the principal that is binded by the contract. So what an agent is doing in totality is to bring the contract, is to bring the principal close to the third party for commercial substance. Is that taken?
Yes, sir.
So that invariably means that a 10-year-old boy can act as a representative of ICAN online tutors,
an aged person,
provided he has the knowledge expected. Do you get? If you are a boss of your own, you can use somebody of 15-year-old as your secretary, provided the lady is good and she can act very well as your secretary. What matters is that you have age capacity. Is that taken?
Yes, sir.
Thank you. I believe at the end of this session, we are going to send you this slide so that you can have something at your disposal to read. Thank you for your question. Mr. Okay? Is it okay or okay? Any other question?
No. Yeah, I think I'm good with liars, calling me liars.
Elias. Okay, that's fine. Okay, what do you have a question, sir?
No, I don't have a question. Thanks.
So you are fine with the topic so far?
Yes.
I think you should. You guys should have questions around this effect of agency contract, because I can love to test that every year. I don't really know why, because it's somehow confusing effect of transaction. So this is explaining who is liable to agency contract. So Mr. Elias, so can you just tell me in simple terms your understanding of effect of agency transaction? At what point will an agent be liable by himself under a contract of agency? That's my question.
Sir, can you come again?
At what point will an agent be liable to a contract under agency transaction?
From what you've said so far, when is above 21?
Okay.
I think it's under when the principal is not disclosed, under an undisclosed principal.
Okay.
I think the agent will be liable.
It's fine. So Mr. Elias, you tried, but the right answer is under undisclosed principal. You see, this heading is very important that you know. But thank you for your attempt. So
but
let me
sir, can I ask a question there, sir?
Go ahead.
I still find difficult to know the difference between the named, in terms of the consequences, between the named principal and unnamed principal, because it seems under both sides, the principal are still liable, but I still don't know the difference between the two.
So in English term, let me just, for example, some of these things are not realistic in practice. So in English term, you have come out to mention the name of your principal, and you're also acting in capacity of the agency agreement. That is what made it a named principal. A very good example are the brand ambassador, most especially during a sales exhibition or promotion. They will call some ladies, they'll give them t-shirts, they'll stand before the products. Are you getting me? They'll be telling you this organization is doing promo, come and buy it, you get. So that's a very good example. By them telling you the name of the organization, you know the principal. By them standing, giving you a flyer and trying to explain to you why you should contract with their principal, you will know that they are acting on behalf of somebody. Am I right?
Yes.
That is a very good example of the principal. So I hope I will not be shooting my leg. I will not be shooting myself in the leg for this explanation that I want to give for name principal. So, you know, most of these house agents, you won't know the principal until you finally agree to pick up a house. Yes or no?
Yes.
However, they made it clear to you that they are just an agent.
Yes.
In this part of my own community, one agent will take you to one house. Once you guys have concluded in getting the house, the money that will be given to that agent will be shared among about 12 agents. So who are those agents that you don't know behind the scene? So that is a very good example of unnamed principal. They didn't tell you the house income on the person, but you know that they are acting on behalf of somebody. Are you there? Yeah, so that's the major difference between them. But the joy is just
but the
that
consequences are same.
Of course, the
consequences under both are same.
Same consequence, especially for exam purpose, we have the same consequence. But in practice, it's a function of how best you can push it. It's a function of how best you can push it. Yeah. So termination of agency explains the process of bringing an agency contract to an end, and this will mark the last subtopic of our class for today. So we have two major ways of terminating an agency contract. An agency relationship can be terminated in two ways, namely by express act of the party or by operation of the law. By express act of the party, let me use agent and landlord as my example. The landlord can decide to discontinue the contract he or she have with the agent. Yes or no?
Yes.
That is by act of the party. So based on mutual agreements. It could also be that we agree that we are going to work together for 5 years, and after 5 years, you cease to be my agent. Are you there? That's a very good example by act of the party. So these are what can be, construed into the contract based on the law or based on what is obtainable in practice. By death of either party, the contract will automatically come to an end. Where one party becomes insane automatically, upon becoming a bankrupt. In law, once you are being declared bankrupt, you will be denied from entering into some business transaction, if not all. By frustration. For frustration of contract, when we get to contract, we are going to explain that further. But most of the time, the reason for the termination is not affected or is not caused by the parties involved. It is sometimes come independently. For instance, this coronavirus pandemic have affected a lot of businesses, yes or no? So if, for instance, you are acting as an agent to a particular business that is grossly affected by coronavirus pandemic, automatically they will retrench you or ask you to leave, yes or no?
Yes.
So it's not that it is caused by your incompetence or it's caused by the company unable to pay you. but it is caused by economic factor. Am I right? So that is by frustration. But when we get to contract, I will explain that in details. So an agency contract can also be brought to an end if it is discovered that we are transacting on a legal transaction. So where the subject matter no longer exists, yeah, maybe for instance, so you're helping me to market a house, I will later discover that the house you are marketing is not even existed. It has been sold many years ago. Then what is the essence of your presence as an agent? What will happen? Automatically we bring the contract to an end. Yes or no? By expiration of contract, I just mentioned that maybe we agree for 5 years and it's already completed. The next thing is for us to just end the contract. Subsequent illegality of either of the transaction or of the status or capacity to either party. So this actually explains that if any of the principal or the agent subsequently entered into an illegal contract and was found guilty, it has a way to affect the existing contract of agency. We have questions to look at. Can we see the screen?
Yes, sir.
Yes, you see this question. I only solve question number 1, or we shall look at it together. And I want your opinion on it. Hassan operates a one-man vegetable business. During his absence on holiday, fresh tomato arrived at the local railway station for him. After several attempts to deliver the goods to Hassan premises, the station manager decided to sell the tomatoes and owed the money in a separate account. Before going on holiday, Hassan left his contact address and telephone number where he can be reached to the station master. Discuss the legal position.
Can you look at the question again?
No problem. You can see the screen. Let's look at it together.
Vegetable business. During his absence on holiday, fresh tomatoes arrived at the local railway station for him after several attempts to deliver the goods at Hassan premises. Half certain and sell tomatoes. I think I'm able to get something there.
Okay, hold on. Mr. Elias, can you unmute your speaker? Unmute your mic. I want us to relate here. Yeah, thank you. Thank you. You can see in business law, like I mentioned earlier, most of our questions will be in form of case study. Only few cases they will give us divine, explain, describe. We've actually looked at this kind of scenario before. But I want us to look at it again here and give our opinion. It's a legal opinion. So I'm listening to you.
Okay. From what you explained under creation of agency, there is creation of agency by necessity. And when looking at the nature of the business, it's about tomato, which is a perishable good and can get spoiled at any time. So that is the reason why the officer decided to sell on behalf of Hassan, which means he acts as an agent. Though it was mentioned that Hassan left his contact and telephone number. So which means before the person who acts as an agent for him is supposed to have contacted him, because part of the condition is you should be able to contact. So you can also act as in terms of necessity if it's not possible to communicate with the person. And the question also mentioned that after several attempts to deliver the goods at certain premises, the station master decided to sell the goods. So which means he made several attempts to deliver the goods at certain premises. But the mistake I think he made was he's supposed to have called him since Hassan gave him his contact, dropped his contact to him, since Hassan dropped the contact to him. So if he had called, that would have been creation of an agency by necessity. So, but if it's not, is not actually confirmed that he's able to, he tried his best to contact him, to communicate with him, and not possible, then I think the agency hold. But if he did not make the attempt, I think the agency did not hold.
Okay. Okay. Thank you so much. Thank you so much. Mr. Elias, do you agree with him? Because me, I did not agree with him. I'm just thanking him for his opinion. Mr. Elias?
I'm with you.
Okay. What's your view? What's your view?
I agree with you.
But I didn't agree with him.
I agree with him.
So I'm wrong? Is that what you're saying?
Sir?
That's okay. That makes sense. That shows that we both are paying attention so far. That's what it means. I'm happy. That's a very good one. You actually tried. I like the fact that you painstakingly put forward your opinion by touching every knocks and crannies of this question. So the truth is, if care is not taken, you feel like the station master has done the right thing by selling and also by putting it in a separate account. It sounds like he has done a good job. But in the principle we are using, the three conditions must be present. The first is that it is impossible or impracticable to communicate with the owner. But in this case, the station master dropped his contact address. Number two is that there is an emergency situation. Yes, tomato in question is a perishable goods and it can get spoiled. So selling it is actually the best option and save the money for the owner. Last, with the interest of the what? The principal. He has actually acted in good faith by opening a separate account. But there is something that is not present in his action. Since there is a way for you to communicate with the station master, with ASEN, then agency by necessity has not been established. Even though every other thing looks so important and emergency in nature, but there is a clause. You can see they gave you at the end of, they want us to get confused at the beginning. Only few people with wisdom will now read it again.
Yes.
To say that before going on holiday, Hassan left his contact
address,
telephone number where he can be reached. I getting me? The telephone master should have called. Whether or not he called, that's not what we need in this question. But what will help us is that he has done the right thing, but no agency of necessity is what created, because all the conditions are not met, and majorly Hassan left his telephone number where he can be reached. So that's your legal position. The legal position is what he has done is good, but it's not in line with agency of what? Necessity. Thereby, Hassan will not be binded by his action. So let's take this as a kind of an assignment. There's what you call delegatus non potest delegate, which means an agent cannot delegate authority that has been delegated to him. Are you getting me? However, there are exceptions. You as an agent, you cannot delegate the authority. You can't. That should be the principle, Abi. But that's not what we are seeing in practice. I know. But let's just go by the theory so that we can pass our exam in one sitting. So let's take this as our assignment. Let's think around it. What are the situations whereby you as an agent, you can delegate? Let me help you with one. Where the custom of trade permits, an agent can delegate. Where the custom of trade permit, an agent can what?
Can delegate. When what? When?
Custom of trade permits.
Okay, custom of state, yes, custom.
Custom of trade. I can't pronounce R very well. Sorry, eh?
Okay, no problem.
Permit. So let me give you a very good example. In ICAN conduct, if a client gives you a particular task and you don't have the technical know-how of that task, you can actually delegate it or subcontract it to experts that can carry it out effectively. Thank you. That marks the end of our class. If you have any question, kindly ask.
Okay, thank you, everybody. Thank you for joining the class. Thank you, Afeez Adebimpe. That was a thought-provoking lecture, and I'm sure the students enjoyed it. So you guys can go ahead and feel free to ask all your questions. Also, I'll be sending a poll now to ask you about your opinion, to give us a feedback on this lecture. Nobody will know who voted, so feel free to choose the option that is applicable to you. So I've sent the poll now, so kindly vote and let us know what you feel about this class. Did you find the class educative and engaging? And would you like to see the tutor again? Let's know. Okay. The other person should please do the same. One person has done that. All right. Thank you very much. I won't also share the results with you guys. So, but I've gotten your lecture. Thank you so much. Thank you. I've gotten the results. So do you guys have any questions? Ibrahim Oladipupo Shitu and Ilyas, okay. Do you have any?
No further question.
Please.
No further question. I've asked all mine.
Okay, so
how soon can we get the recording?
Yeah, so the recording will be available during the week. So make sure that you are subscribed to our YouTube channel and you turn on post notification on our YouTube channel.
Okay.
Yes.
And when is our next class?
So it will be available on YouTube. The lectures will be available on YouTube very soon.
When is the next class, please?
The next class will be next weekend, and we are working on a timetable so that we won't just be posting links at of different times. So we're hoping that by midweek there will be a timetable that you guys will be using. So and also encourage you to join the Telegram group if you have not joined yet. That's where is our best way we communicate with students. So kindly join the Telegram group if you have not joined the group.
So
I don't.
Okay.
Yeah, we have a Telegram group. Go to our website, icanonlinetutors.com.ng, and click on ICAN on the menu. Then scroll down to the end. We have a group for each of the courses. So we have the one for business law, management information, down to all the 15 courses at the professional level. So join the groups that are applicable to you.
So can I ask a personal question, please?
Okay, please do.
Yeah, please go on. Myself or Mr. Adebimpe?
For you, sir.
Okay, I'm listening.
Okay, it's concerning. I think while chatting, I guess that you are the one I'm chatting with anyway. The courses I'm supposed to do as reflected on my dashboard, management information system, management information, FA, and business law. But someone was telling me probably everyone has to do taxation also, which I don't know. and I've not seen that on my.
Okay, is
my
this the first
laptop.
time? Is this the first
Yes,
time you are writing?
yes, this is my first
Okay,
time.
what did you study?
Banking and finance.
Banking and finance.
Yes,
Okay,
and
you
it's
know,
when I did the exemption, I'm asked to write these three.
okay. So you know what? I will confirm for you. Kindly chat
Okay,
me up later. I'm not sure if
okay,
banking and finance students are supposed to write taxation. I'm not
okay.
sure. So kindly chat with me. The person, before they wanted to implement the. Okay, sorry. Okay. Let me know, because before they wanted to implement the new syllabus, which means that they took taxation to the skills level. But now that
Yes.
they have suspended it to November, maybe they've now returned it back to, they probably returned it back to the foundation level, and you might not be eligible to write it.
Okay.
Yeah, so that's it. So any
Okay.
other
But I
questions?
think I think I'm supposed to see it on my dashboard if I tell I'm to write.
Yes, you are supposed to see it on the dashboard, but even sometimes it takes ICAN some time before they
Okay.
do some things like
Okay.
that. Yeah.
Because I'm still seeing 3 courses there.
So if you are seeing 3 courses, continue preparing for those 3 courses. But
Okay.
chat me up later, I would confirm for you.
Okay. Thank you, sir.
You're welcome. Will that be all for now?
Yes, sir.
Okay, so thank you for being part of the class. Afeez Adebimpe, thank you so much. And we hope to see you guys next weekend.
Yes, sir.
Okay, have a nice day.
Thank you, sir.
Bye.